Today in this video we are going to discuss about the Indian Penal Code 1860 இந்திய தண்டனை சட்டம் 1870. Actually we are going to see 5 sections in this video, section 1 to section 5. Actually the law is divided into substantive law and procedural law. So the substantive law discusses about the crimes and punishment. Actually the Indian Penal Code is known as substantive law, which deals about the nature of crime and corresponding punishment for the crime committed. That is discussed in substantive law. In procedural law, the laws such as Indian Evidence Act, Criminal Procedure Code and Civil Procedure Code, these are all discussing about the procedure to be adopted while dealing the case. Now we are going to see the sections 1 to 5. Actually this Indian Penal Code, this law was enacted during 1860, but it came into force from January 1, 1862, and then this includes some of the items mentioned in Manu, which is adopted from time immemorial in India. But even in Manu also there is some the disparity of the treatment in awarding punishment. So for example, some of the higher caste were not punished in accordance with the lower caste. That also is there in Manu. Now we are going to see the 5 sections in this. First section 1 deals about the title and the operation of the code. The title is known as the Indian Penal Code, and it extends to the whole of India except Jammu and Kashmir. So that is the title and operation of the code, and it discusses about the criminal law. Second, the section 2 prescribes punishment for offences committed in India. So the offences committed in India for which the corresponding punishment is to be given, and that is dealt in section 2, that is punishment of offences committed in India. And then the third one, the punishment for the offences beyond India but which by law may be tried within India. Suppose if an Indian citizen commits an offence in foreign countries, and then it can be tried in India as if the crime is committed in India. That is the section 3 says punishment for offences committed beyond India, that is beyond, but which by law may be tried within India. That is, if though he has committed offences outside India, it will be treated on par with the offences committed as if in India, and punishment will also be given accordingly as if it has been committed in India, and it will also be tried in India. Then extension of code in extraterritorial offences, that is extraterritorial offences. Some of the offences are committed in extraterritorial offences. Say for example maritime zones, that is called extraterritorial limits. Those limits are called maritime, as mentioned in Maritime Zone 1981, that is 24 miles contiguous zone. Contiguous zone means which is adjacent to the land, that is contiguous zone. The sea starts from the land, that is called contiguous zone. That is called 24 miles contiguous zone, and then the 200 miles exclusive economic zone or continental margin, that is 200 nautical miles. So the 1 nautical mile is equivalent to 1.852 kilometers. So out of all these three limits mentioned, whichever is greater is taken into account. Suppose if that zone is exclusively will be treated as if the crime committed in India. Beyond that, and the fishing right is also allowed within this limit, and beyond this limit, the fishing it is not the fishing zone of that particular country. So the three limits are prescribed, that is 24-mile contiguous zone, 200 miles exclusive economic zone, and continental margin of 200 nautical miles. 1 nautical mile is equal to 1.852 kilometers. That is 200 into 1.8 means it will be around around 360 kilometers. It will be from the margin of the sea. It will be about 200 nautical miles is allowed. Within this area is termed as the zone which is the original. Say for example, if it is India, it is Indian Maritime Zone, and beyond that the fishing right is not allowed. Suppose within this zone, if the foreign country fishes in this area, then it is punishable, and certain laws not to be affected by this act. For example, some of the crimes which is not affected by this act means, say for example, some in army or the military staff, they are governed by certain laws and regulations on their own, and suppose if they desert the military, they will be punished as per the military law, and hence these laws will not affect the original law of the martial law, which is governed for punishing the personnel who are not obeying the rules of the military. Say for example, desertion of the army, like that. So certain laws not to be affected by this act. So this act will not rescue those persons who are going beyond their military power and other things. That is, certain laws not to be affected by this act. So these are all the things. 5 sections are suggested in this Indian Penal Code 1860, and we can apart from this we will say something about the offences. It clearly indicates the Penal Code is meant for offences, that is for white collar crimes and socio-economic crimes, scams, bank frauds, and then hawala and crimes, criminalization of politics. All these are coming under offences, and for this the Indian Penal Code will take its own course for punishing the persons who are going beyond the law, that is Indian Penal Code. And classification of, as regards classification of code, this is divided into 2 divisions. One is called general principles and another is called special offences. In general principles, introduction, general exceptions, punishments, and then general exceptions of abetment and these are all criminal conspiracy, attempts committing offences, and then these are all coming under general principles. And special offences are offences affecting the state, offences affecting the property, offences of common well-being, human body, and then offences relating to marriage and offences relating to reputations are all special offences. that is specific offences. With this, we conclude this Indian Penal Code section 1 to 5.